Distinguished guests and participants, ladies and gentlemen, greetings from Singapore. Welcome to the first panel session on family justice in Singapore, a defining moment. My name is Chia Wee Kiat. I'm the Deputy Presiding Judge of the Family Justice Courts of Singapore, and it's my pleasure to be the moderator for this session. For family practitioners, few would disagree that family cases are some of the most challenging to handle. Unlike other matters, disputes that come before the family court often signal a serious and sometimes tragic breakdown in a person's most intimate relationship. As is often the case, parents who are embroiled in marital conflicts may be so overwhelmed by emotions that they fail to see the perspective through the eyes of the child. What does the child really need in this moment of crisis in the family? Family justice poses many unique challenges such as this, with no easy answers. It's not surprising, and it's indeed heartening to see that in many jurisdictions around the world, there has been a constant search to find new, better, and more innovative ways to deal with these difficult issues. This too has been the story of Singapore. Despite our relatively short history, Singapore has seen many momentous milestones in the development of our family justice system, and we are today at the cusp of a defining moment. As much as we have learned from the experience of other jurisdictions, we are delighted today to be able to share with you the experience of Singapore. On this note, it gives me great pleasure to introduce our keynote speaker, Justice Debbie Ong, the presiding judge of the Family Justice Courts. Justice Ong began her legal career as a law academic at the National University of Singapore's Faculty of Law in 1989, specializing in family law. A published writer, her works are prolific in the law on the family, children, and international issues in family disputes. Justice Ong joined the Supreme Court bench in 2014 as a judicial commissioner and was appointed judge of the High Court on 30th September 2017 and presiding judge of the Family Justice Court on 1st October 2017. Justice Ong is undoubtedly an expert in the field of family law. My fellow judges and I have benefited tremendously from the depth of knowledge and insight, and if I may say so, from standing on the shoulders of a giant. And so without further ado, I shall hand over the floor to Justice Ong. Justice Ong, please.
Madam Halimah Yacob, President of the Republic of Singapore, patron of the 8th World Congress on Family Law and Children's Rights, the Honorable the Chief Justice Sundaresh Menon, Chief Justice of Singapore, the Honorable Diana Bryant, AO QC, Chair of the Board of the World Congress, Mr. Yap Tiong Liang, Chair of the Law Asia Family Law and Family Rights Section, members of the Board of the World Congress, distinguished guests, ladies and gentlemen. I'm delighted to be a part of this World Congress conference. We in Singapore had looked forward to hosting every participant on site in Singapore last year. Unfortunately, we could not, but I'm happy we can meet this way across the miles and time zones. The conference theme, Through the Eyes of a Child, resonates deeply with us at the Family Justice Courts. The driving reason for a specialist family court is the presence of children in the proceedings. Children may be the subject matter of court orders, yet they are not parties to the proceedings. When the Family Justice Courts was established in 2014, our Chief Justice exhorted us to assist families towards the path that will bring healing, like doctors diagnosing a problem and choosing the right treatment for restoration. Our aspiration is to help the parties to move away from a painful past and to recast their family's future. This address is entitled Family Justice in Singapore, a Defining Moment. In order to see why this is a defining moment, I will first share what sort of moments we used to have. Let me start with our early beginnings. This year, 2021, is the 60th anniversary of the enactment of our key family law statute, the Women's Charter. This statute has the title of Women's Charter because of its place in an important part of Singapore's history. In 1958, Singapore's constitution was revised. It gave Singapore self-government and its people could elect its own leaders. In 1959, the political party, the People's Action Party, or the PAP, presented a manifesto that addressed the issues on the economy, housing, education, and employment. The PAP promised to raise the status of women, uplift the economy, and increase the opportunities for education and employment of women. The party was eventually successful in being the majority elected to lead Singapore in self-government. To raise the status of women, local customary marriages which allowed polygamy had to be abandoned. The Women's Charter was enacted in 1961. It introduced monogamy and largely provided for the equality of the legal status and rights of husbands and wives. The Women's Charter provided one marriage law for all except for Muslims. These events in history explain why our family law legislation is called the Women's Charter. This statute itself is a piece of our history, enacted during the birth of an independent Singapore, intimately connected with the development of a new nation. I highlight one particular provision in the Women's Charter. Section 46(1) of the Women's Charter sets out our society's aspiration of how marriage partners should behave. It provides, upon the solemnization of marriage, the husband and the wife shall be mutually bound to cooperate with each other in safeguarding the interests of the union and in caring and providing for the children. The other subsections in section 46 go towards fulfilling the promise to raise the status of women, providing for the wife's equal status in a marriage. The role of section 46(1) is in some way like that of a mother provision, a sort of higher order provision within a statute that regulates many aspects of family life. There is no specific punishment or remedy for a breach of this provision. Yet section 46 remains a legal provision of immense importance. It sets out the very core obligations of the husband and wife. As it imposes the duty on spouses to safeguard their union, it would be reasonable to expect from both spouses real efforts at resolving their disagreements amicably and to treat each other with respect. Where spouses are also parents, they must not let their conflict hurt their children. These are legal obligations. They are not just relationship advice. If, unfortunately, the spouses reach a point where safeguarding the union becomes unachievable, the law allows a different course of action, but one which still mirrors the same goal. That is, it allows a divorce, but one which should cause the least bitterness and trauma for the family. Because children still need their parents to care and provide for them, a divorce does not entirely end the relationship between divorced spouses in their capacity as parents to their children. Thus, the second part of section 46(1), the obligation in caring and providing for the children, endures beyond divorce. And the family justice regime can demand that this legal duty be discharged by separated parents. Requiring bitter ex-spouses to be cooperative might seem to be an oxymoron, a contradiction in reality. But if we look through the eyes of a child, this is exactly what the child needs. And if we believe that the child's needs are paramount, then we cannot simply accept that the parties cannot cooperate and they need not behave better because it's hard for them. Professor Leong Xin Yu, a leading family law academic in Singapore, exhorts in a discussion on section 46(1). She says, the law cajoles spouses to try to reach the ideal, but refrains from trying to punish each failure. The courts may astutely use every appropriate opportunity to affirm the legal exhortation. Indeed, punishing every failure within the context of family relationships does not sit well with our endeavors to support healing and recasting of a positive future. On the one hand, the law should not be too quick to intrude into family relationships, which are rather intimate in character. On the other, family law must be interventionist to some extent, because there is a cost to the children's welfare when marriages break down. Our family justice system has evolved over the years to achieve a less adversarial, more supportive journey for divorced families. I share some milestone developments in this chart. The court system has developed over the years to bring our family law principles into the practical journey of divorce. The very first form of the family court was established in March 1995 as one of the divisions in the subordinate courts of Singapore. It handled cases relating to maintenance, family violence, and adoption. The next year, in 1996, jurisdiction to hear matters relating to guardianship, custody, nullity, divorce, and ancillary matters was transferred from the High Court to the Family Court. In the same year, an in-house court counselling unit was set up. Court counsellors provided short-term counselling in divorce cases to help parties to manage their emotions, explore reconciliation, and assist parties in reaching informed decisions. It provided support to family members involved in domestic violence, carrying out risk assessments, and facilitating safety plans. They also prepared evaluation reports on child custody and access to assist the court. In March 2002, the Family and Juvenile Justice Center, or FJJC, was established. The FJJC's multidisciplinary team included social workers, counselors, psychologists, and mediators. In 2009, FJJC's Psychological and Counseling Unit was rebranded as the Counseling and Psychological Services, or CAPS for short. In 2008, the CHILD program was launched. CHILD was an acronym for the Children's Best Interest Less Adversarial Program. The program aimed to achieve a less adversarial and more expeditious hearing of disputes involving children, and it had an intentional focus on the best interest of the child. The child court facilitated greater participation by the parents and was supported by the court's family counselor. The family court judge would take an active role in the conduct of the hearing. The parties and their lawyers sat around a specially designed table which encouraged face-to-face communications between the parties. The parties would take their oath at the same table and could give evidence there, seated or standing up. The child court was effective, but resources could not sustain its long-term use. In January 2011, Parliament amended the Women's Charter to provide for mandatory counselling and mediation for couples with minor children who are divorcing. In September 2011, the Child Focused Resolution Center, or CFRC, was set up. Family court mediators, family counselors, and court administrators work within the CFRC to assist divorcing parties with minor children. These efforts over the years were endeavors in building a multidisciplinary approach, which included inputs and support from psychologists and counselors. In 2013, the Chief Justice appointed a committee to review the family justice system in Singapore. Acrimonious litigation of family disputes was a problem that needed to be addressed. Pursuant to the recommendations in this committee's report, the Family Justice Court was established in October 2014. The Family Justice Court comprised the High Court Family Division, the Family Court, and the Youth Court. The new Family Justice Act was enacted, and the Family Justice rules followed suit. The Family Justice Court adopted a judge-led approach to ensure expeditious proceedings, and this meant a more proactive management and conduct of family proceedings by specialist family judges. The reforms arising from the 2013 report were reviewed for further enhancement in 2018 by the Committee to Review and Enhance Reforms in the Family Justice System, called the RERF, or RERF Committee. As presiding judge, I co-chaired this committee with the permanent secretaries of the Ministry of Law and Ministry of Social and Family Development. This enabled wider enhancements to be made in an area which needed a multidisciplinary approach beyond legal remedies. In 2020, I shared the work plan of the Family Justice Court to adopt a non-adversarial system that delivered therapeutic justice. In my work plan address last year, I quoted from an article that divorce should be no worse than a reorganization of family members' living arrangements, and the divorced spouses should still be able to continue to discharge their parental responsibilities with some degree of cooperation. Spouses whose marriage has broken down can obtain a divorce, but they must do so in a way that will enable them to still cooperate to the highest degree possible in discharging their parental responsibilities to their children. The family justice system should be a non-adversarial one, a system that is problem-solving. It will seek to deliver therapeutic justice, or in short form, TJ. TJ is a lens of care through which we look at the extent to which laws, rules, legal procedures, practices, and roles of the legal participants produce helpful or harmful consequences. A TJ system builds the hardware structure and the software resources that will ensure therapeutic, helpful effects. This is so that the parties can find healing and a way forward. We are building training programs to equip our judges and lawyers to practice in this TJ environment. They are examples of TJ software. It is important that we also ensure that the TJ hardware, the court system itself, with its rules and processes, support the software. Both are vital to produce the therapeutic effects we aim for. The essence of therapeutic justice and the reason we adopt it is for parties to be enabled to find healing and a way forward. The non-adversarial system is the hardware, the structure in which we believe is required to achieve the delivery of therapeutic justice. This aspiration to move towards a more harmonious resolution of family disputes began years ago. Nearly 2 decades ago, major amendments to the Women's Charter strengthened the law and the aspirations towards a less adversarial resolution of disputes. Section 50 provided that a court may give consideration to the possibility of a harmonious resolution of the matter and may, where the parties consent, refer the parties for mediation. It may take many years to fully achieve what Section 46 in 1961 had first intended. For all of us working in Singapore's family justice system, it has been a long journey of never resting on what has been achieved and never pausing just because something appears impossible. One example comes to mind. It used to be thought that if parents were in high conflict, they would not be able to make joint decisions. So it was the lesser harm to have just one parent make important decisions for the child. In a 1995 decision, the High Court remarked, sometimes it is better for a decision of sole custody to be made, even if it turns out that the perfect option is not chosen, rather than for the matter to be the subject of conflict between the parents. Then there was resistance to joint custody, which was the authority for both parents to make joint decisions in important matters relating to the child. Sole custody was frequently ordered where parties appeared acrimonious or unable to cooperate. Sole custody meant that one parent could exclude the other parent in making significant parenting decisions. But in 2005, our highest court in Singapore, the Court of Appeal, took a different step, a brilliant one, if I may say so. In the judgment of CX and CY in 2005, the Court of Appeal stated in no uncertain terms that the preferable position in the law of custody is to preserve the concept of joint parental responsibility, even if the parties may harbor some acrimony towards each other. Often, advocates rely on the acrimonious relationship of the parties to argue that joint custody will be detrimental to the welfare of the child. However, they fail to appreciate the fact that some degree of acrimony is to be expected when parties are undergoing the stresses of a marital breakdown. The time when the marital breakdown occurs may not be the best time to assess whether both parties can cooperate for the rest of the child's life. It is a leap in logic to assume that the parent's inability to cooperate during the period of divorce equates to an inability to agree on the future long-term interests of the child. Since this landmark decision, it has been widely accepted that joint custody is in the child's welfare and is the recognized norm. Sole custody is the exception. This remains our law today. Yet, I am aware that there may be naysayers who continue to doubt. If divorcing parties are so full of acrimony and deep hurt, is it realistic to expect them to take a cooperative approach to parenting? Is it realistic to require that they do not behave as adversaries in court? Should parents be deprived of a good fight in court? An enlightening development in our family law jurisprudence shows us the way. In the very recent decision of VDZ and VEA, the Court of Appeal held that therapeutic justice is not merely an ideal, it is a necessity and is intensely practical. Relationships constitute the very pith and marrow of a family. When familial relationships break down, those relationships are damaged. Such damage cannot be repaired completely by material recompense. Healing needs to take place. Healing cannot even begin to take place if the parties are in an antagonistic relationship. Still less when parties wage war against each other. A kind act begets a kind response, while a nasty act inflames the other. For more than 2 decades, counseling and psychological support services have always been provided as a key part of the family's divorce journey in the family court. I have briefly shared the milestone developments over the years. Adopting a multidisciplinary approach is not new. Providing counseling and mediation isn't new, but as long as these come within an adversarial system, the full positive effects of such beneficial services will always be undermined. A counselor might encourage the parties to let go of past hurts and vengeful thoughts, to look instead towards healing and co-parenting. Yet, at the very same time, if parties are receiving antagonistic letters in the course of their adversarial litigation, it will be hard to think about forgiveness and letting go. Instead, it'd be very easy to think about writing even more hostile letters to your spouse who's about to be your ex-spouse. The adversarial system undermines healing and the therapeutic aims of support services. The two tracks must align. We cannot give with one hand and take away with the other. The therapeutic justice system, being our aim, will have no place for inflammatory letters, no place for antagonistic court battles. This defining moment in our journey of family justice abandons the adversarial system. In a country where its long-standing legal system is the traditional common law adversarial system. Our family judges and lawyers have been trained in the adversarial system. How do we embrace this somewhat unfamiliar, maybe even uncomfortable way of practicing? A client may be upset with her lawyer who refuses to write an aggressive letter to the other spouse. What can the lawyer do? We need new skills to be effective in this environment. Lawyers and judges must move ahead with the same mind and will. I envisage that our family law jurisprudence itself will develop in line with these aspirations. The judgment of the Court of Appeal that I have just quoted is a truly significant jurisprudential development. Not only is therapeutic justice adopted as a necessity, the Court of Appeal instructs that parental responsibility is crucial to the child's welfare. Let me highlight the following passage in the judgment. The Court of Appeal continued in the same judgment. What occurred in the present case was an extreme example of such warfare, and consequences of such an approach are negative in at least two ways. First, healing cannot even begin to take place. And without such healing, parties and their children will find it extremely difficult, to say the least, to move forward with their respective lives. Second, the damage that results will impact not only the former spouses, but also the children. The parties in the court always act in the best interest of the child. Phrased as a legal principle, the welfare of the child is paramount. It is unfortunate that the children, in this case, were forced to pick sides and turn against their father, with whom they previously had a healthy relationship. However, the wonderful thing about life is that it is never too late. We would urge the mother to reflect seriously on her life as well as her future actions. We hope that she can put aside her negative attitude and emotions and encourage the children to restore their relationship with their father. It undoubtedly requires courage to take this positive step on behalf of the children. This passage highlights what it might take to uphold the child's welfare. The child's best interest is intimately entwined with the proper discharge of parental responsibility. To have the children pick sides and suffer a conflict of loyalty is failing to discharge parental responsibility. The parent who shows disappointment or even anger when the child tells him or her that she had a wonderful time with the other parent undermines the child's welfare. The Court of Appeal was fully aware of the depth of acrimony, but still exhorted the parties that it was never too late. And both parents should take courage to do what is needed for the sake of the children. One ubiquitous legal principle in most family law systems is that the welfare of the child is paramount consideration. Article 3 of the UN Convention on the Rights of the Child states that in all actions concerning children, the best interests of the child shall be the primary consideration. Parties and lawyers seeking orders over children know the welfare principle very well. They cite it to the court to support their arguments. For example, they may say that it is in the welfare of the child to spend more time with them, but not with the other parent. The welfare principle may have been used too casually, without thought, such that its true meaning has been lost to many. I explain what I mean by this in the following case. The case of VDX and VDY was a high court decision involving cross appeals that revolved around only two narrow issues. First, which parent would have control of their youngest child during dinner time on Chinese New Year's Eve? And second, when the father should return the youngest child to take care of the mother after the year-end school holidays. These arrangements were not specified in the original orders made 7 years ago. So for 7 years since the divorce, the parties had been able to work out such practical and specific arrangements themselves. I discussed only the first issue, which parent will spend dinner time with the child on Chinese New Year's Eve. In Singapore, families come together on Chinese New Year's Eve for a family reunion dinner. This dinner is an important tradition and of great significance to those who celebrate Chinese New Year. In the lower court, the judge took a pragmatic approach and ordered that the child could have an earlier dinner with the mother before joining the dinner at the father's home later at 8:30 p.m. Both parties argued that the judge's order was not workable. Both submitted that the child and his siblings should not commute between two dinners, and that the DJ, the district judge, had failed to give full weight to the acrimony between the parents, which made this arrangement untenable. The mother submitted that alternating arrangements for dinner on Chinese New Year's Eve every year was the best way to achieve parity, while the father submitted that the children should have dinner with him and his extended family, while the mother could have lunch that day with the children. The High Court held the present issues, whether resolved in the way the mother proposed or in the manner the father proposed, would not significantly affect the welfare of the child. What would significantly affect the welfare of this child is the parents' conflicts and the spirit in which they carry out the orders. If the arrangements are carried out by each parent with the intent to ruin the time with the other parent, then the child's welfare will be undermined. On the other hand, either of the arrangements proposed by the parents, if carried out with a supportive and cooperative spirit, could and would go well and promotes the child's welfare. Is one arrangement in the child's welfare while another is not? Whether one arrangement might be more comfortable than the other for the child on just that night, Chinese New Year's Eve, may in fact depend on the child's particular circumstances on that day, such as the parent's support, his mood, his school schedule, or as he gets older, his plans with his own friends. What was important was that the arrangements proposed by the parents and the final arrangements in the DJ's order would not, between them, significantly affect the child's welfare in a fundamental way. The father also alleged that the mother did not limit how much the children ate when they had the early reunion dinner with her, and the children were too full to eat the second dinner with him. Such issues go into how the broad care arrangements are carried out, and the point made above, that is, it is the spirit in which the parents carry out the arrangements that matters. How each parent supports their children and their time with the other parent is part of discharging parental responsibility. The child's welfare isn't only about where she eats dinner and how her week is physically split up between the two parents. It is so much more than that. The child's welfare is just so much more than this. It is much about the spirit in which both parents discharge their parental responsibility. The discharge of parental responsibility is critical to the welfare of the child. To speak of upholding the child's welfare without applying the legal requirement of parental responsibility misses something far too fundamental. If parental responsibility is integral to the child's welfare, the only way forward is to put in place a family justice system that compels the discharge of parental responsibility in Section 41(1), which mandates that parents are mutually bound to cooperate with each other in caring and providing for the children, even after a divorce. The journey towards that place where separated parents can cooperate is not easy. Waging war in an adversarial system is the opposite of conduct that is responsible parenting. Practices such as sending provocative letters, filing affidavits that highlight the worst of each other, encouraging young children to file affidavits against a parent, all grate against healing and moving forward. We must ensure that the TJ hardware, the court structure and its rules and processes support the TJ software of effective lawyering and supportive therapeutic services. This is a defining moment because we are taking steps that will make a colossal difference to families and the children of divorce, because we are looking through the eyes of a child. As defining moments go, they tend to require a lot of hard work, an enormous mindset change, and courage. My colleagues in the family justice courts will share more on what our family justice system is and endeavors to be. Thank you for having me participate in this conference. Thank you for being here with me, and may you enjoy every session in this conference packed with really important discussions. Thank you.
Thank you, Justice Ong, for taking us through the momentous milestone in the development of the family justice system in Singapore and setting out a clear vision on the bold steps needed that will make a huge difference to families and children of divorce. Indeed, we are in the throes of a defining moment in Singapore. And to take the discussion further, I'm pleased to introduce our next speaker, District Judge Yani Loy. DJ Loy had a distinguished career in private practice as a corporate litigation lawyer before she joined the courts in 2014. She's also trained in counseling and worked in a family service center during her counseling studies. DJ Loy is a key architect in conceiving and implementing some of the important family justice initiatives that give practical meaning to the concept of therapeutic justice, TJ. I can think of no better person to speak on this subject than DJ Yani Loy. And so over to you, DJ Loy.
Distinguished guests, ladies and gentlemen, a very good day to all of you. At this point in FJC's journey, we have tremendous opportunity to make the right choices and take the right steps towards positive and lasting change. Today, I'll share the efforts that we are taking to enhance a TJ and multidisciplinary problem-solving approach within the courts. I will also share our efforts to make specialist training available to family judges and lawyers. Positive and lasting change can only happen if the stakeholders in the family justice system believe that change is necessary and desire to make a difference. And one of the most important keys to changing mindsets is through training, so that we all speak a common language and share the same vision. Our presiding judge has given a comprehensive overview of our milestones leading to this defining moment. I will therefore jump straight to the year 2020. 2020 was an important year for family justice in Singapore. It was not just the year of the pandemic and virtual hearings. It was also the year when FJC articulated its vision to deliver therapeutic justice. In a workplace speech in May 2020, our presiding judge, Justice Debbie Ong, articulated FJC's renewed vision to evolve into a truly problem-solving court, one that is non-adversarial and that delivers therapeutic justice. To support our vision, we also formed a targeted advisory and research council to bring together international TJ scholars and thought leaders to serve as our resource panel to assist us in implementing our TJ vision and plans. As you know, TJ is a method of thinking. It looks at the law as a social force that may produce therapeutic or anti-therapeutic consequences, whether intended or not. It is a lens of care through which we can look at the extent to which the legal landscape of substantive laws, rules, and legal procedures, that is the hardware, as well as the role and behavior of family justice participants, that is the software, can produce helpful or harmful consequences. This TJ lens invites us to think of ways to build better TJ hardware and software for our own courts, tailored to our own unique local needs. And we need both good TJ hardware and software. And today I'll focus on just two important aspects of our TJ plans. First, to build more good TJ hardware in terms of the court process through a multidisciplinary team pilot. And second, to enhance our TJ software through the training of our court actors. In terms of court process, FJC has initiated a multidisciplinary team pilot. Currently, the court process is a largely linear two-tier process. In the first year, parties attempt court mediation and counseling, which are intrinsically excellent problem-solving TJ hardware. And the majority of cases do settle at court mediation. However, a not insignificant number still require adjudication. For cases that do not resolve at court mediation, parties have to proceed to the second tier, namely the adjudication stage. At this stage, unless a case is docketed to a single judge, different judges will handle the matter and hear different applications involving the family. Whilst the judge-led rule was introduced to give a judge more power to manage the case, the philosophy at the adjudication stage at the moment is still largely adversarial, which is not quite aligned with our TJ vision of a problem-solving and non-adversarial court system. How can we change that? When the judge-led rule was introduced, the intention was to create a collaborative and problem-solving space, even at adjudication. The judge-led rule was inspired by the civil law inquisitorial system, which is judge-led as opposed to party-led. As explained by our Chief Justice, The judge-led frame was adopted to create a dynamic space for litigants, lawyers, witnesses, and the court to collaborate and undertake a joint effort to resolve issues and find solutions. So what more can be done in terms of our court process so that as far as possible, a problem-solving approach does not stop and end at mediation, but continues even through to adjudication? This is where the multidisciplinary team pilot steps in. Under this pilot, high needs and high conflict cases involving acrimonious parties with complex child issues and on multiple court proceedings are identified at an early stage and assigned to a single multidisciplinary team to manage. Each team is led by a hearing judge and includes a court mediator, court family specialist, and case manager. The team closely manages the case and supports the family and is intentional in customizing an approach that is best suited for the case, which does not have to follow the two-tier process. Parties and counsel are also reminded that they too are part of the problem-solving team and are expected to adopt a collaborative problem-solving mindset. Through this combination of early triaging, close management and support by a single multidisciplinary team, lawyers who are hopefully collaborative, and greater direct involvement of the parties, it is hoped that the underlying needs of the family can be addressed more effectively through early intervention and support, that there's a reduction in unnecessary acrimony and court filings, and that court outcomes, be they mediated outcomes or adjudicated outcomes, are enduring and sustainable, with parties motivated to become their own problem solvers. The pilot commenced in late 2020, focusing on high needs cases to start with. It will be reviewed in due course to assess whether and to what extent such an approach can be adopted and applied more widely in the court. This MDC pilot is an important step in our continuing efforts to better refine our court processes to move towards a problem-solving and non-adversarial system. Much as we need to continue to examine and refine our court processes, we also need to focus on our software, which brings me to my next topic, namely changing the mindsets of family justice court actors and shaping culture through specialist training. Through a TJ lens, family judges and lawyers have to be conscious that they operate as therapeutic agents and hold much power to impact families and children. It is widely recognized that family judges have much more of a problem-solving role than those of their judicial colleagues. A family court judge cannot work in a silo by himself. He or she functions less as an adjudicator, but more as a conflict manager, overseeing, coordinating, and motivating a multidisciplinary group of service providers. Possessing the right legal qualifications is not enough. Family judges need to be able to identify the root underlying causes of family disputes, manage emotional and distressed litigants sensitively with empathy and respect, and have the authority and confidence to make appropriate therapeutic referrals to help families and children address root concerns. Recognizing the specialist nature of a family judge's role, we have been devoting resources to provide training for our judges. In 2019, we introduced a multidisciplinary training curriculum and committed to setting aside an annual dedicated learning week for the training of family judges. Our very first learning week was held in July 2019. Due to the pandemic, the second learning week was held virtually earlier this year in February. Our curriculum focuses on the concept and delivery of TJ and relevant social science topics. The modules include bench skills such as TJ communications, practices, and techniques, as well as interpersonal and basic mediation skills. Relevant social science topics such as basic child developmental psychology, the impact of trauma and adverse childhood experiences on children, mental illness and family violence, and the importance of parenting and co-parenting. We also have modules on the social service landscape and available specialist support services and referrals in the community, as well as modules on judicial wellness, self-awareness, and self-care. The faculty comprises leading experts in different disciplines. They include High Court justices, international experts, leading academics, psychiatrists, sociologists, psychologists, and other mental health specialists. Yet training cannot stop with judges, but must be made available to family lawyers too. We all know that family lawyers are often the first responders who come into contact with the parties well before the court, and who have great power to influence the trajectory of a case at their very early stages. There are many good and collaborative family lawyers practicing in a TJ way, but more can be done. Not infrequently in court, parties will share with us their deep distress and anger at receiving court papers and reading what has been written about them. Some have shared their feelings of deep betrayal and hurt at receiving and reading court papers, portraying them in a deeply negative and hurtful light, laying bare their most intimate matters and private exchanges. This drives them to retaliate by engaging their own lawyers to file even more acrimonious court papers, worsening already strained relationships and deepening family crises, often with children unfortunately caught in the crossfire. Many lawyers may not even be conscious of the impact of the court papers filed. They are, after all, merely doing what they have been trained to do, what they know how to do, namely, to put forward their client's best case and inflict damage on the other party's case. If initial communications and court papers are handled and drafted differently from the outset, can things turn out differently? Around the world, there has been growing awareness that family lawyering should emphasize the important role of lawyers as problem solvers and peacemakers, working collaboratively in a multidisciplinary environment. This does not mean that they have to become professional counselors. However, they need to be able to understand the client's underlying issues, which are very often not legal, so that they can point the clients in the right direction. And when FGC first articulated the renewed TJ vision last year, it also actively engaged in outreach efforts with family lawyers through various practice forums, dialogues, and discussion platforms. A working group has since been established comprising representatives from FJC, Singapore Academy of Law, and the Law Society to put together a specially curated voluntary certification program that aims to equip family lawyers with additional specialist skills to be even more effective family lawyers. The program will focus on TJ, relevant social science topics, and practical aspects of adopting a problem-solving approach in court. The first run is scheduled to be rolled out later this year. At a future date, specialist accreditation will be introduced. It would be for experienced family practitioners who are experts in handling more complicated family proceedings involving divorce and children, including cross-border cases. The training of family judges and lawyers is essential because most legal professionals have been schooled only in the common law adversarial tradition. When we engaged with family lawyers and sought feedback on our renewed TJ vision last year, family lawyers identified training, culture, and changing the mindsets of all legal actors as some of the most important ingredients needed to fulfill the TJ vision. When more and more family judges and lawyers come to embrace a different method of thinking, to embrace our problem-solving, non-adversarial vision and its importance to family court work, we will reach a tipping point in our efforts in culture and mindset. This will also augur well for any future reforms of court processes and rules to more fundamentally pivot towards a problem-solving and non-adversarial family justice model, so that we have even better TJ hardware to support our TJ software. What is also important for the future will be to teach TJ to law school students, to shape their mindset before they even start family law practice. FCC has therefore been in discussions with our 3 law schools to bring TJ into the law school curriculum. I've spent some time talking about specialist training because it is an important key to unlocking our family justice vision. It will teach us to think more deeply about the work we do and how we can do it better. It will play a big role in changing culture and mindsets. It will guide us individually and collectively as a generation of family justice court actors make the right choices for Singapore's family justice system to move us towards our TJ vision of a non-adversarial, problem-solving court. By working together with all our stakeholders and with continued strong progressive leadership from the top, we can and will leave a positive and lasting legacy for families and children in this little red dot we call our home. Thank you.
Thank you very much, DJ Loy, for that passionate articulation of what TJ entails in practical terms. Quite clearly, a lot of deep thinking is required to transform vision into action, and not to mention the will and capacity required to bring together the many different legal actors and pieces to make it happen. One of the key pieces of the TJ tapestry is the need for a multidisciplinary approach, which brings me to our next speaker, Ms. Leong Xin Yu. Ms. Leong is a registered psychologist serving as a senior court family specialist in the Family Justice Court since 2016. She will share with us how the Family Justice Court in Singapore has integrated social science into the dispute resolution process to help families find a way forward. Ms. Leong, please.
Distinguished guests, ladies and gentlemen, greetings. I'm representing the Counselling and Psychological Services. In short, we are called CAPS. CAPS consists of a team of professional psychologists, counselors, and social workers collectively known as court family specialists. Today, I'll be sharing some brief history of CAPS, the role of CAPS in the courts, our work or partnership with various stakeholders, as well as the role of CAPS in relation to therapeutic justice. So some brief history of CAPS. Counseling was introduced in 1996 in the then subordinate courts family division. So that was the time where there was increasing recognition on the limitations to pure judicial legal interventions. So behind the legal disputes, there were sometimes other underlying concerns such as psychological or emotional related issues. As such, counseling was introduced for selected cases, for instance, those in which there were specific concerns pertaining to children, or cases where there were concerns pertaining to psychological or emotional well-being of the family. The Juvenile Court joined the Family Division in 2001. Counselling support was expanded. Counselling was no longer just limited to divorce cases, but also juvenile-related issues. Steady developments took place over the years. There were also various names given to the services that we had. I won't trouble you with the details or acronyms, but in short, in 2009, CAPS, Counselling and Psychological Services, we got our name. 2011 was a defining moment for CAPS. That was the year where counselling and mediation were made mandatory for couples who have filed for divorce and have children who are minors. So this was really an approach where the courts provided parties the avenue to resolve their issues without going for trial. This was also a collaborative and multidisciplinary process. So the counselling aspect was provided by CAPS, the court family specialist, and the mediation component was conducted by the judge mediators. I'll provide more details on the role of CAPS shortly. The next historic milestone was 2014. That was when the Family Justice Court was established. Aside from major organizational reforms, there were also developments to the clinical practices of CAPS. One of the most significant changes was the greater emphasis on the best interest of the child, which included the importance of the child's voice being heard. So over the next few years, in addition to seeing parents for counseling, where suitable, the counseling process sometimes also included the children. The role of CAPS is multifaceted, but in the time I have today, I will focus on 4 areas. So the role of CAPS includes providing counseling support, conducting forensic assessments, assessing and managing risk-related issues, as well as providing support to the youth courts. So first, counseling support. Divorce is a major component of our work. Unlike many other cases that come to court, family disputes in particular are high on emotions, possibly because relationships are at stake. So here we are talking about spousal relationship, parent-child relationship, and possible major changes to daily routines and living arrangements. So these issues are complex and sometimes cannot be completely resolved purely by legal solutions. So even in divorce, for example, parents remain parents, children remain sons and daughters and siblings to each other. So relationships have to be managed during and even after the conclusion of the court proceedings. Counseling and mediation are major aspects of our divorce work in the family courts. They are targeted for cases where parents have children below 21 years of age and they have yet to fully resolve all issues relating to the divorce. So for instance, it could be about the divorce itself, about children issues, money issues, housing issues, etc. So counseling and mediation are mandated for such cases, meaning that parents do not call up to apply or request for counseling. Counseling is itself part of the court procedure. So in this process, CAP's role is to provide the counseling support. The objective of the counseling is to help parents to focus on the needs of their children. So during the counseling session, the court family specialist engages the parents and facilitates discussions or dispute resolutions on the issues at hand. So this could be about the care arrangements of the child, access or visitation arrangements, etc. In addition, counseling serves an educative function to encourage parents to resolve the differences between themselves, to minimize exposure of the children to the acrimony, and to encourage parents to work towards co-parenting. Where possible, the court family specialist seeks to help parents to arrive at an agreement on the care plan based on the best interests of the children. As mentioned earlier, based on the needs of the family, the court family specialist might also request to have counseling with the children. By having sessions with the children, the court family specialist seeks to understand issues at home from the lens of the child. The court family specialist also assesses underlying emotional or psychological concerns pertaining to the child, and thereafter continues to engage the parents to provide feedback relating to the child and also to discuss possible support that the child might require. So typically after counseling, parents move on to the next stage of the proceedings, which is mediation. Mediation is facilitated by judge mediator. So CAPS, we work very closely with the judge mediator by updating on specific concerns or underlying issues pertaining to the cases so that the judge mediators can also continue to support the parents during this next phase of the proceedings. So for CAPS, we provide the therapeutic and social science expertise, while the judge mediators, they provide their mediation skills and legal expertise. By combining both components, we hope that the court can offer a less adversarial and perhaps a more therapeutic setting for the families. Next, forensic assessment. CAPS also provides forensic assessment within the courts. Sometimes there are cases where despite the counseling and mediation, parents are unable to come to an agreement pertaining to the custody or care arrangements for the child. So this is a situation where the case has proceeded for trial. So in such situations, the judges sometimes direct an evaluation be conducted. So this is in essence in the nature of forensic assessment. CAPS is involved in conducting these rigorous evaluations to assess the needs and welfare of the child in question. The evaluation report is then prepared to assist the court in deciding on matters relating to the care arrangements of the child, as well as the support recommended for the family. Third, risk assessment and management. Risk assessment is another major component of our work. We have a team of court family specialists which specializes in assessing risk pertaining to family violence. Sometimes it might also involve violence or neglect pertaining to a vulnerable adult. So we have family members coming to apply for what we call the personal protection orders due to the violence that has been inflicted on them. So these family members, they hope that obtaining such an order will deter the other family members from inflicting violence or harm on them. As there are safety concerns or risk involved in these cases, CAPS play a major part in the risk assessment. So this includes evaluating the risk of recurring family violence, identifying protective factors, establishing safety plans, and so on. In cases where there are high risk and minimal protective factors, CAPS will take relevant steps to ensure the safety of the applicant. In cases where there are more complex needs, for example, where there are mental health related issues, substance abuse, CAPS will then make the arrangements for the individuals to receive the relevant support. The fourth category of work I will touch on is the work of CAPS in supporting the youth courts. The youth courts deal with several types of cases. For first, it could be youth arrest cases where these youths are involved in risky behaviors such as rioting, unlicensed money laundering, theft. The youth courts also deal with cases pertaining to child abuse, parental neglect. Some of the cases also involve the youth running away from home, girls being at moral danger, etc. So in supporting these families, there are discussions between judges, advisors, and relevant professional agencies on issues pertaining to key concerns and progress of the cases, as well as the recommended support plan. So CAPS is actively involved in these discussions. CAPS also facilitates family conferences. These family conferences are attended by the youth, his or her family member, and professional agencies or caseworkers supporting the youth or child. So the family conference is a platform where parents, agencies, they come together to discuss suitable intervention plans for the child or the young persons who is in need of statutory intervention. So the ultimate aim really would be to protect the vulnerable, to empower the family systems, and to restore strained relationships. So some of you might be thinking, if there is an in-house CAPS team, are we still required to then collaborate with community partners or stakeholders? The answer is a definite yes. Our support is limited to the lifespan of a case in court. But as we know, family issues extend far beyond that lifespan. For example, there are many adjustments to be made following a divorce. Furthermore, the issues encountered may be wide-ranging, including mental health-related issues, grief over the loss of a marriage, trauma in children or spouses after years of family violence. For these reasons, we often leverage on the strengths of our community partners to provide the necessary long-term support. So other than post-court support, sometimes support is better provided upstream. For instance, pre-divorce support can provide parents the access to divorce-related information and services. So these are some of the agencies that we work with. They include the family violence specialists, divorce support specialist agencies, child protection services, and etc. So in short, CAPS, we believe strongly in the importance of community partnership and supporting the families, and such partnerships, they are a valued and integral part of our work. We have heard the Chief Justice, Justice Ong and DJ Loy, speak about therapeutic justice. So what is CAPS' role in advancing TJ? First, therapeutic support. As we have heard across our various areas of work, a large part of CAPS' role is in providing that therapeutic support for families, and we do so as early as possible. Second, problem solving. We seek to work with families to problem solve the issues at hand. So these could be divorce-related issues, child-related issues, co-parenting issues, safety issues. Third, contributing towards a multidisciplinary approach. The multifaceted nature of our work calls for such an approach. The legal approach is certainly an important aspect in a family dispute. However, we also see the benefits of complementing this with psychosocial perspectives. So for CAPS, we work closely with judges, legal personnel, various stakeholders, and partners in supporting the families. Over the years, we have seen visible and encouraging progress in relation to the support provided for families who come through our doors. During this journey, we at CAPS, we have experienced many defining moments, and there are surely more to come. For the move towards a better family justice system is a continual quest. Together with many like-minded professionals who are joining us here today, may we continue to press onward and upward. Of course, the defining moments are not just limited to systemic improvements, important as those may be. May those who have little option but to turn to us, these broken families, the people in distress, may they also experience their own unique defining moments as they embark on their journey of healing, of restoration, and of renewed hope for the future. Thank you.
Thank you, Ms. Leong, for that presentation. We are reminded through Ms. Leong's presentation that family law cases are made out of broken families and children. Each family has its own unique set of challenges and vulnerabilities as they navigate the legal system. CAPS plays an integral role in the TJ tapestry, not only as a bridge between the legal and social science pathways, but also in providing timely intervention and support for the judges and the families through the expertise. But even as we slow down to focus on the humanity and the uniqueness of each person and each family that comes before our courts, there is a need to speed up to keep pace with the rapid technological advances in the fast-changing world. This brings me to our final speaker, DJ Daraso, who will touch on how FJC has leveraged technology to improve access to justice and enhance the quality of court services. DJ So has been serving as a district judge and assistant registrar of the Family Justice Courts since 1st July 2015. As one of my younger colleagues, he is one of the most IT-savvy judges in our courts and is spearheading some of our most important IT initiatives. So over to you, DJ So.
Thank you, DYPJ, and good day, everyone. Since FJC was established in 2014, FJC has been consistently finding ways to leverage on technology to enhance access to justice. I will be giving a broad overview of specific innovations that we have worked on, our journey thus far, and the direction to which we are headed. In order to better understand and contextualize our journey, it is critical to first understand the various case management systems in operation within FJC. These case management systems were developed at various points in time, and they each provide the underlying infrastructure that harnesses our innovation journey. 3 systems are currently in operation, serving different types of matters handled by FJC. E-litigation that handles the bulk of our matters, the integrated case management system, and the integrated family application management system. Later this year, FJC will be launching the Lit Assist system, and this will focus on divorce applications as a start. I will touch on more about Lit Assist and the key features of the new system and our design philosophy later in my presentation. Instead of going into the details of each of our case management system, I find it useful to touch on key technology and innovation components across the systems that we have worked on that have expanded access to justice at various stages of a case life cycle. These are namely the application stage, the pre-hearing stage, hearing stage, and post-hearing stage. Most of our applications can only be commenced through a lawyer or coming down to our physical premises or the service bureau. Where possible, we are moving the commencement of applications online. By transitioning applications online, we will be able to bring in several innovations to mitigate the pain of form filling. We can put in place a step-by-step process to guide court users on the information required so that the process is less overwhelming. With the user's consent, the system can also pull basic personal details that are housed in other government repositories such as MyInfo. This will mitigate, again, the pain of form filling. In the future, Singaporeans and long-term pass holders will be able to take advantage of the National Digital Identity Framework to digitally sign the required court papers. Completed forms can now be captured as structured data so that if there are further requests and applications during the case life cycle, they can be automatically populated as well. In the future, we may move towards a fully digital process where we can have structured data without any forms. Court users can make payments online instead of coming down personally or through their lawyers. We also understand that not all of our court users may be comfortable with technology. We have therefore worked with our community partners to be connected to our case management systems to provide direct technical assistance in the filing of their applications. A significant number of litigants in FJC are self-represented. These litigants may not be familiar with the legal process and principles. As such, FJC has designed free online toolkits for common matters so that litigants will have the essential background information when conducting their case. Where possible and appropriate, we will move our court notices and pre-hearing requests, such as requests to reschedule court matters or updating their contact details online. This means that court users are less likely required to take time off their schedules to come down to our physical premises, and they can make such requests at their convenience. At the same time, we want to continuously encourage and provide parties opportunities to resolve their disputes amicably. With COVID-19, FJC ensured that mediations continued, even if during safe distancing requirements, we continued using video conferencing as a default. In the future, we want to expand similar opportunities by referring parties to private mediations and neutral evaluations. Prior to COVID-19, FJC permitted limited video and telephone conferencing options. However, COVID-19 led to FJC pivoting to video conferencing as the default for its hearings and trials. FJC produced training videos, technical guides, and guidelines for both lawyers and litigants to smoothen the transition to remote hearings and trials. As a result, court users are able to participate in their matters from home. Video conferencing also brought the added advantage of facilitating the sharing of documents during the hearing so that all attendees can follow their case. For court users who do not have a conducive environment or the necessary equipment, FJC created rooms on our premises for them to use. Court officers were also trained to provide technical assistance either on-site or over the phone. For the post-hearing stage, we have digitized several processes to increase efficiency in court communications and access to court processes. Referrals to external agencies have been made contactless with soft copy-only forms. Court users can also quickly check the authenticity of court orders through QR codes, and maintenance debtors who have been ordered to show proof of payment can do so online. We have several enhancements lined up as well. We have observed that many parties experience difficulties in phrasing court orders that they have to extract after the hearing or when submitting the orders. To assist these parties and so that all court users have a common reference point, we have compiled the most commonly used orders, and we will make these available to users online in the third quarter this year. Once codified orders are integrated into our case management systems, we hope to have the eventual court orders generated soon after a judge makes his or her orders. We have referred to many of our future plans, and many of these will be effected through Lit Assist. Lit Assist is a breakthrough portal that will provide a set of litigation tools to all court users and lawyers. For a start, the portal will focus on helping litigants and lawyers generate and file divorce applications, and this will be launched at the end of the third quarter this year. This will be a guided process with the option for users to auto-populate their personal details housed in government systems. If they would like to engage a lawyer, whatever documents the system has will be downloaded to their preferred lawyer through an access code. In time, we hope to expand Lit Assist incrementally to the other applications and to include further tools so that both court users and lawyers that require at all stages of a case life cycle. As such, Lit Assist is both a case management system as well as an articulation of our design philosophy. Each of the technology and innovation components I mentioned earlier throughout my presentation can be deceptively simple. A lot of hard work and resources have been invested in its development. Given the limited time of this presentation, I'm only able to give a superficial overview of what FJC has done or will be doing. If anyone has any queries, please feel free to drop me an email at the mentioned address in my next slide. Thank you.
Thank you very much, DJ So, and to all our speakers. Having heard from all our speakers, let us move into the Q&A segment. If I may begin with a question for Justice Ong, and of course, I will invite the rest of the panelists to give your views as well, if you have any. Now, a judge, do you think Singapore's unique family justice journey could provide learning points for other jurisdictions contemplating reforms and review of the national system?
I think every jurisdiction's unique journey will provide lessons for all of us. As for our journey, I think that the challenges that we face at each milestone step are probably the most useful information. If I were to pick two broad challenges, it would be mindset change and resources. These two challenges sort of affect each other. To achieve a positive mindset change, you want to ensure that all your initiatives are effective and assure everyone of the benefits that can be achieved. And to do your initiatives well, you need to have resources, funding, time, manpower, and you need to ensure that your new steps that you take are sustainable. These are all parts of a big tapestry. We in Singapore have made a number of overseas study trips in our journey. We've been to Australia, London, Germany. I think that our various jurisdictions should have more conversations with each other. There's just so much to share, and we would welcome that.
Judge, I'm wondering, since we're on this topic about the learning from other jurisdictions, perhaps in the area of international cooperation, what do you see are some promising and perhaps potential areas where more progress can be made?
Well, the International Hague Network of Judges, formed for connecting judges in jurisdictions committed to the 1980 Child Abduction Convention, is a fine example of international cooperation. In fact, the fourth global meeting of the Network of Judges was originally planned to be held last year on the sidelines of this World Congress Conference, but now we are deferring this to next year. I think that apart from a network of such a large international community like the International Hague Network of Judges, we can work on cooperation within our region. For example, the Council of ASEAN Chief Justices have yearly meetings, and the discussions there enable greater understanding of the laws and cooperation amongst the 10 ASEAN jurisdictions. The ASEAN Law Association also brings lawyers in the ASEAN countries together in this way. Country-to-country bilateral agreements on specific areas of law and practice are superb ways to increase international cooperation as well. These can be set up in a fairly straightforward way, and yet the benefits are very substantial.
Thank you, Judge. I'm just wondering whether any of the other panelists would like to comment on this. Well, if there's none, I do have a question on TJ, and this question is for DJ Loy. What do you think are the critical success factors for the implementation of TJ narrative? And what are some challenges that have been encountered so far in efforts to carry out the TJ plans?
I will start first with the challenges. Like TJ, I believe changing mindsets is not easy. When I first heard Prof. Wexler, the father of TJ, speak about TJ at a seminar in Singapore a few years ago, I was immediately struck by its simplicity and profound relevance to the work that we do in the family courts. But this could be due in part to my background and training in both adversarial litigation and counselling before I joined the family courts. So persuading others to also accept the TJ lens was a different matter. They've all been schooled in the common law adversarial tradition, and to now ask judges and lawyers to change the way they think and do things, that's a huge challenge. So I think it was not surprising that when PJ introduced TJ in her work plan speech last year and mentioned plans to provide specialist training for family lawyers, it did create some disquiet and unease amongst the lawyers. But we have come a long way since with our TJ plans and with more court actors believing in it and becoming actively involved in shaping the TJ vision. And I'll now mention what I think are 3 important drivers of change. First, strong progressive and supportive leadership from the top. And I think we are really fortunate in Singapore to have our Chief Justice and Presiding Judge helming our efforts. Second, community and stakeholder engagement. It is not good enough to have a good product or a good idea. Others must also believe in it. As such, over the past year, a lot of work has gone into our engagement and outreach efforts with judges, lawyers, and other stakeholders through huddles, discussions, meetings, and forums. And finally, specialist training. I think in terms of immediate impact, training will help the individual lawyer or judge in terms of acquiring relevant knowledge, skills, and techniques to handle a particular case in a problem-solving and non-adversarial way. But training goes beyond that. Ultimately, these very same individuals are the ones who will have a say and a stake in shaping any future legislative reforms to make our court processes and hardware more aligned with a problem-solving and non-adversarial approach. Because we do need good TJ hardware to support our TJ software. And this can only come about if more and more family court actors, including judges and lawyers, believe that such change is indeed necessary for an all-rounded TJ vision.
Thank you, DJ Loy. Since we are on the topic of TJ, perhaps I could direct a question at Ms. Leong. Ms. Leong, how do you see the role of CAPS further evolving under the TJ framework?
I will approach this question from 2 perspectives, one from the clinical perspective and the other from the systems perspective. From the clinical perspective, I think we need to keep our fingers on the pulse of changing social circumstances. One area in which we can expect to encounter rapid changes relates, I think, to the increasing complex needs of children in distressed families. Some children, they exhibit alarming stress, anxiety, and other mental health related symptoms. There are other problems that are possibly exacerbated by cyber age developments, such as gaming addictions or exposure to inappropriate materials online. So I recall seeing an 8-year-old child where he was very much exposed to long hours of online videos. When I met him, a large part of his play and talk was on themes relating to death and of hurting himself and others. So these are very sobering manifestations of real problems, and CAPS, we recognize that these are issues, and we continue to equip ourselves to better understand and support the mental and emotional well-being of these children who find themselves unfortunately embroiled in court proceedings. Supporting the children or families is no longer just about determining the custody, care, and control access issues. It is also about being mindful of these other psychological issues that can have an impact on the relationships in the families, and to support by providing holistic and practical solutions to the issues at hand. So that would be the clinical perspective. From the systems perspective, we have to continually embrace and explore new and innovative methods, looking beyond the traditional approaches in counseling and psychology. So CAP's response to the COVID pandemic, I think, provides a good illustration. We had to pivot almost overnight to technology-facilitated services for the first time. We certainly had our reservations about the viability and efficacy of such approaches. However, over the past 1.5 years, we have experienced firsthand, perhaps necessity is truly the mother of invention. So speaking personally, I found it really meaningful to explore virtual interaction with parents and children. So such sessions allowed me to observe firsthand the interaction between parents and their children in their comfort zones, or so-called their natural habitats. So this would unlikely have been explored so rapidly had we not been forced by circumstances to operate remotely. The virtual interaction model also provided us the opportunity to explore using tools and games to interact with children over digital platforms in a manner which they were familiar with, and which could also hold their attention despite the distance. Another point about systems, I think, would be the need to build stronger network of specialists, which I've shared earlier during the presentation. CAPS, we recognize that we are a small team and the needs of our clients extend far beyond our boundaries. So we continue to seek to build stronger and wider partnerships to address these varying needs of the family. I think moving forward, we must be prepared to continually evolve our practices so that we can continue to provide that optimal counseling and psychological services to the families that come to us. Thank you.
Thank you, Ms. Leong, for that substantive response. I think it may be useful now to perhaps turn our discussion a little to technology. And that's this question is directed at DJ So. Now, as FGC taps more and more on technological solutions to improve access to justice and service levels, a question that arises, and this is an important question, how would FGC deal with the challenge of the widening digital divide between savvy and non-savvy litigants, and to maintain the high touch factor that is critical to facilitate a measure of healing for those involved?
Emotive matters often require that high touch factor that you have rightly pointed out. I recall a few years ago when I first joined FJC, I was struck by the in PPO applications, personal protection order applications, whereby the applicant often breaks down in court when they have to recount their experiences of family violence. And we have court officers that will put a hand over the applicant's shoulder, listen to them during the break, providing them tissue paper. You really cannot replicate such human touch. But we can mitigate this somewhat by understanding and appreciating that we right now we are operating on the digital platform. So, for example, how the judge appears on the screen is important. How eye contact is effected is important. It may be something simple, a simple solution like adjusting the angle of the webcam, but it makes a huge difference. So such tweaks may help so that court users don't feel the social distance that technology sometimes bring. However, we cannot see technology as mutually exclusive because technology can sometimes enhance experiences in our court in certain ways, where a family violence victim is fearful of being in the same physical premises as her tormentor. Technology can be that enabler. It's therefore important that FGC continues to maintain an attentive listening ear so that we can identify gaps as and when we roll out various innovations or technology products so that we remain perceptive and adaptable. Just to give you one example, when COVID-19 was on the ascendancy, we thought about how safe distancing will impact our court users in continuing that access to justice, be it applying for a personal protection order or applying for maintenance. We invested time and resources to develop our video conferencing capabilities, and we identified potential gaps. One of those potential gaps was for court users who are not tech savvy or may not have the ideal environment in their homes to participate in a court hearing. So we quickly planned for space within our premises, and we call it Zoom rooms, so that court users can come in and use the equipment there so that they can effectively participate in the hearing. And over time, we noticed that some court users gain confidence to use their own mobile devices, and they no longer needed to use Zoom rooms either for their matters when it comes to trial, or if they have a repeat matter, they can do it in their homes. So we also cannot rely on ourselves to identify these gaps. One way to do this is for FJC to maintain strong partnerships in the community, like Community Justice Center, so that they can provide or relay critical feedback on what is working or what needs some refinements.
Thank you, DJ So, for the response and for those practical tips. I was thinking about getting the rest of the panelists to provide some comments, but having look at the time, I think we have run out of time and we have to bring the session to a close. So in closing, let me thank our panelists for their insights and presentations. I would like to express also our warmest appreciation to the 8th World Congress for giving us this invaluable opportunity to share Singapore's experience and also to learn from the experience of other jurisdictions. On behalf of the Singapore Family Justice Courts, let me thank our friends and participants from all over the world for taking time to join us in this session. It leaves me only to wish everyone, wherever you may be, a very fruitful conference ahead and to stay safe and healthy. Thank you.
Thank you.
Thank you, DY. Thank you all.
Thank you.